Welcome to the Deep Dive. Today we are taking on a legal and financial beast. Chapter 7 of Title 11 U.S. Code.
Right.
Forget the simplified movie version of bankruptcy. This is the ultimate complex financial reset button, formerly known as liquidation. When people talk about a fresh start in the U.S. debt system, they are more often than not talking about Chapter 7.
And that's exactly what makes this dive so crucial. Chapter 7, which people often call straight bankruptcy, is the most common form filed.
By individuals and businesses, right?
Both, yeah. It really reflects the harsh realities of the modern economy, but we need to define it crisply. Chapter 7 is pure liquidation.
Meaning things get sold off.
Exactly. Assets are sold. And that's totally different from, say, a Chapter 11 or a Chapter 13, which are really mechanisms built for reorganization.
Where you're trying to restructure things and keep going.
Precisely. You're making a plan to make payments. Chapter 7 is the end of the line for those debts.
So our mission today is to cut through that complexity and really understand the mechanics, but also the philosophy behind it. What is the price of that fresh start?
And that price has changed. It changed fundamentally with the Bankruptcy Abuse Prevention and Consumer Protection Act, or BAPCPA, back in 2005.
Right. BAPCPA. We're going to be talking about that a lot.
We have to, because that act didn't just change the rules, it changed the entire narrative around who deserves liquidation.
Exactly. We're tracking this tension between the old American ideal of the fresh start and this more modern legislative push toward creditor protection.
So we'll detail the process for businesses first, then for individuals, and then, we're going to devote a lot of time to decoding BAPCPA.
Especially that infamous means test.
Yes.
But before we even jump in, we should probably note a critical gatekeeper for individuals.
Good point.
You can't just file whenever you want. If a debtor has had a prior bankruptcy case dismissed within the last 180 days for certain reasons, they're just blocked.
Right. Things like failing to follow court orders, or if you voluntarily dismissed your case after creditors tried to claim assets.
So it's a system designed to prevent people from using bankruptcy as a sort of perpetual delay tactic.
Exactly. You can't game the system that way.
Okay, let's unpack the path for a financially troubled business first. When a corporation or a partnership files under Chapter 7, this is it. This is the definitive end.
It really is. This isn't just closing the doors. It's a court-supervised termination and a dispersal of value.
It's the legal equivalent of dissolving the entity.
That's a great way to put it. The business ceases operations immediately. A trustee is appointed by the court, virtually right away.
And that trustee takes over.
Complete control of the entire entity. Now, they might briefly continue operations, but only for a very specific reason.
Like what?
Say, to fulfill a high-value contract that makes the remaining assets more valuable for a sale. But their sole purpose, their only mission, is to maximize recovery for the creditors.
So this trustee, who's often a highly specialized lawyer or accountant, is basically stepping in to liquidate the entire business as fast and effectively as possible. What kind of powers are we talking about here?
The trustee has enormous authority. They can look at transactions that happened before the filing.
A look-back period.
Exactly. They're looking for fraudulent transfers or, preferential payments made to one specific creditor right before they filed. Their primary directive is to consolidate all the assets, turn them into cash, and then distribute that money.
And that distribution follows a very strict hierarchy, right?
A strict statutory hierarchy laid out in the Bankruptcy Code.
So this is where the financial risk you took before the bankruptcy really comes into play. We hear that investors who took the least amount of risk get paid first. How does that work?
It all comes down to the concept of security. If you loaned money to the company without securing that loan against a specific asset, you are an unsecured creditor.
But if you did back it with collateral,
then you are a secured creditor. You inherently took less risk because you had a fallback plan. You had the asset itself.
Okay, let's make this concrete. Imagine a mid-sized manufacturing company files for Chapter 7. Who is at the back of the line?
At the very bottom are your unsecured creditors. That's the vendor who supplied the office paper, the consultant who was owed fees, maybe some general unsecured bondholders. They only get paid if there's money left over after everyone else.
And just above them.
You might have some priority claims, like certain unpaid wages or taxes, but the real priority is at the top.
The gold standard of protection.
That's the secured creditor. It's often a bank or a specialized lender who, say, financed a specific piece of production machinery. They have a security interest, a legally recognized claim on that machine.
So when the company liquidates,
The bank has the right to repossess that machinery or get the cash from its sale.
and you even noted a category called fully secured creditors. How strong is their position, really?
Their position is nearly impregnable in a Chapter 7. A fully secured creditor is someone where the value of their collateral is equal to or even exceeds the debt they're owed.
So if a bank loaned $1 million for a piece of property, and that property is still worth, say, $1.5 million,
And the bankruptcy court generally cannot defeat that creditor's right to either the property or its value. They are made whole, or as whole as possible, no matter how much the unsecured creditors are hurting. The system rewards that careful underwriting.
okay, so the secured creditors get paid. The trustee sells everything else off patents, inventory, office furniture. The cash goes to the unsecured creditors, and the case closes. But here's that critical distinction: the discharge. For a company, the debt doesn't actually get wiped out.
That's one of the most misunderstood aspects. Unlike with an individual, a corporation or partnership does not receive a bankruptcy discharge.
And that's written right into the law.
It's explicit in the code. So while the company has liquidated everything and the case is closed, the underlying debts are not legally erased by the court.
That seems almost academic. If the company is gone and has no assets, why does it matter that the debt technically survives?
Because it fundamentally defines what Chapter 7 is for a business. It's not a fresh start, it's an orderly funeral. The concept of a discharge is a release from personal liability.
And a corporation isn't a person.
It's a distinct legal entity. Once it dissolves, the debts are practically uncollectible, yes, but they theoretically exist until the statute of limitations runs out. If a hidden asset was later discovered,
Creditors could still go after it.
they could. It just highlights that for a business, this is all about asset administration, not about financial absolution for the entity itself.
It's the difference between a definitive clean slate and just having $0 in the bank. And that makes the shift to individuals all the more profound. For them, the fresh start is the entire point.
Exactly.
So transitioning to the individual debtor, someone living in the U.S. owning property here,
Yeah.
this is where the emotional and financial stakes are just so much higher. The promise is a clean slate, but that promise requires you to surrender assets.
Right. The core mechanic is the same. The trustee liquidates assets to repay creditors. But, and this is a huge but, the individual gets to keep exempt property.
This is the safety net.
It's the safety net built into the system. It's designed to ensure the debtor doesn't emerge from bankruptcy completely destitute, unable to function or restart their life.
And the power dynamic here, how much you can protect, is entirely dictated by state lines.
Wildly dictated by state lines, yes.
Yes.
Exemptions, the value you can shield in a home, a car, your retirement accounts, are determined by state law, or sometimes federal law if the state lets you choose.
The difference can be huge.
Oh, massive. Some states have incredibly generous, even unlimited homestead exemptions. You can protect a huge amount of equity in your primary home. Other states are far, far stricter.
So someone facing bankruptcy in Texas, with its famous homestead protection, might walk away keeping their home, while someone in another state could lose it entirely for a similar amount of debt.
That's the painful reality of the geographic variance. It's a huge factor in pre-filing planning. It can determine whether Chapter 7 is even a viable option if you want to protect your biggest assets.
Let's talk about the elephant in the room for individuals: mortgages and car loans. If I file Chapter 7 and get a discharge, does the debt on my house just disappear?
No. And this is another crucial misconception. The vast majority of liens survive the bankruptcy.
Okay, what does that mean?
Remember the bank that financed your car. They still have a security interest, a lien, attached to that car. The bankruptcy discharges your personal liability for the debt.
So they can't sue me for the money.
They can't sue you personally, but they absolutely retain the right to repossess the collateral if you start making payments.
So if you want to keep the house or the car,
You have to keep paying.
so bankruptcy eliminates the stick, the threat of a personal lawsuit, but the creditor still holds the collateralized carrot.
Perfectly put, the debtor has to choose: surrender the asset or reaffirm the debt, which means agreeing to keep making payments to keep it.
Now let's get to the heart of the fresh start. The difference between dischargeable and non-dischargeable debt. A lot of unsecured debt, credit card bills, medical debt, it gets wiped out.
It does. But there is a huge basket of debts that the law says are, well, fundamentally non-negotiable.
And this list represents some core policy choices, right?
Yeah.
about what society values.
It really does. It prioritizes certain obligations over the goal of a clean slate. The biggest categories involve family and the government.
Family obligations seem pretty intuitive.
Absolutely. Child support, spousal support, alimony, none of that is dischargeable. BAPCPA even clarified that property settlements from a divorce are also generally non-dischargeable.
And the thinking there is,
These aren't commercial debts. They're transfers of existing family obligations. Wiping them out would just shift the financial burden to another family member or, to the state.
what about taxes? Can you get rid of debt to the IRS?
Rarely. Taxes are complicated, but the general rule is strict. Income taxes less than 3 years old are non-dischargeable.
So recent tax debt stays with you.
It does. Property taxes, too. And if the debt is tied to legal misconduct like fines and restitution from a criminal case, those also survive. The law isn't designed to be a get-out-of-jail-free card.
That brings us to the one that causes so much distress for modern debtors: student loans.
Student loans remain the Mount Everest of non-dischargeable debt. They are not discharged unless you can win an adversary proceeding.
Which is basically a lawsuit within the bankruptcy case.
A full-blown lawsuit, yes. And you have to prove undue hardship.
We hear that term undue hardship a lot. What does it actually mean? Is it enough to just show that paying is really, really hard?
Not even close. Most courts use what's called the Brunner test. It sets an exceptionally high bar.
Okay, what's the test?
It's 3 parts. First, you have to prove that based on your current income and expenses, you can't maintain a minimal standard of living if you have to repay the loans.
Okay.
Second, you have to show that this situation is likely to persist for a big chunk of the repayment period, meaning it's a long-term or permanent problem.
And
that you've made good faith efforts to repay the loans before you filed for bankruptcy.
Wow. That test seems designed to filter out almost everyone who isn't facing a truly catastrophic and permanent financial disability.
It is. The result is that most student loan debts survive Chapter 7. You only get relief if you are, say, permanently disabled or elderly with no real income potential. It shows that the government views this debt as a long-term investment you can't just shed.
But no matter what, whether the debt is dischargeable or not, you have to tell the court about everything, right?
Absolutely. Even the debts you know will survive, like child support or recent taxes, they have to be meticulously listed on your bankruptcy schedules. The court needs a complete, transparent view of your entire financial world.
And if you don't disclose something,
That can be grounds for denying your discharge altogether.
let's discuss the financial fallout, the 10-year shadow.
A Chapter 7 bankruptcy stays on your credit report for 10 years from the day you file. That is a formidable mark. It definitely impacts your access to prime credit for a full decade.
And that's different from a Chapter 13.
Right. A Chapter 13, the reorganization path, stays on your report for 7 years. The difference is small in practice, but it reflects the legal distinction. Chapter 13 shows an attempt at repayment, which the system views a little more favorably.
But you brought up a crucial counterpoint earlier. For someone who files Chapter 7, their credit may already be destroyed. Does the bankruptcy filing really make things that much worse?
Often, no. By the time someone files, they're typically way behind on payments, their debt-to-income ratio is shot, and their credit score is already at rock bottom. Filing Chapter 7 often stops the bleeding.
It provides a floor.
It does. And crucially, creditors often start extending new credit pretty soon after small loans, secured credit cards, because that new debt is not covered by the discharge. So the debtor, now free from old obligations, is ironically seen as a slightly better risk for small amounts of new debt. It's a strange paradox.
Before BAPCPA came along and changed everything, the U.S. trustee could already challenge a filing as abusive. This was the precursor to the means test, right?
Yeah. It was. It was a more discretionary, judge-driven process, but the core question was the same. Can the debtor actually afford to pay?
So the trustee would look at someone's finances and say, hey, wait a minute.
You have enough disposable income to fund a 5-year Chapter 13 repayment plan. The goal was always to divert people with income into repayment instead of liquidation.
And if the trustee succeeded,
The court could deny the Chapter 7 discharge. That would effectively force the debtor to either convert to Chapter 13 and start a repayment plan, or just have their case dismissed entirely.
so that discretionary challenge was the battleground that led to BAPCPA.
It was. Lenders wanted to take that discretion out of the judge's hands and replace it with a fixed mathematical formula, and they got what they wanted.
The pre-2005 system relied on this subjective, though legally rigorous, assessment of abuse. And then enter the Bankruptcy Abuse Prevention and Consumer Protection Act, BAPCPA.
Right. It went into effect on October 17, 2005. And it was the largest, most consequential reform to U.S. bankruptcy law since the big overhaul in 1978.
This legislation wasn't passed overnight.
No, this was the result of almost a decade of intense lobbying, primarily a huge financial institutions, credit card companies, and lending associations.
And their argument was what? That people were abusing the system.
Their core argument was that too many people who could afford to repay their debts were using Chapter 7 to just walk away from them. They wanted a strict, objective measure to prevent this perceived abuse.
So the goal was explicit. Make Chapter 7 harder to get.
The whole intent was to impose new hurdles, stricter financial tests, longer waiting periods, mandatory educational requirements, everything designed to limit the fresh start to those who were genuinely without the means to pay.
And push everyone else into Chapter 13 repayment plans.
Exactly. The law essentially shifted the burden of proof. It became the debtor's job to prove they deserve the discharge.
And even just the process of filing, the paperwork itself, became drastically more complex.
Oh, absolutely. The official federal bankruptcy forms became exponentially longer, more detailed. The sheer complexity asking for all this information on asset transfers, income averages, mandatory expenses, it became almost impossible for a normal person to navigate without professional help. It turned the filing into a monumental administrative task.
Which brings us to BAPCPA's main event, the means test. This is the mathematical formula designed to enforce that shift from liquidation to repayment. How do we even start to decode this thing?
Well, the means test is the primary gatekeeper for Chapter 7. The first thing to know is that it only applies to individual debtors whose income is above their state's census median income.
So that's the first hurdle. If you're below the median for your state.
You're generally assumed not to have the means to pay, and you get to skip the really complex calculation.
But if you are above that median, you're in for the detailed financial analysis. What's the core structure of that?
It's a statutory attempt to figure out if you could fund a Chapter 13 plan. It's a 60-month disposable income-based test.
So a 5-year projection.
Right. The calculation takes your income, subtracts a whole bunch of standardized and actual necessary expenses, which are often based on IRS collection standards, not your real living costs, and then it multiplies that resulting disposable income by 60.
And this leads to the dreaded presumption of abuse.
Yes. A presumption of abuse is found if that projected 60-month disposable income is higher than a certain threshold. If the math shows you have enough disposable income to pay back a reasonable chunk of your debt over 5 years, the court presumes you're abusing Chapter 7.
Okay, here's where the means test seems to just break with common sense. How it calculates your income. It uses a historical average, not what you're making right now.
This is the most criticized part of BAPCPA. The means test calculates your income based on the prior 6 calendar months leading up to when you file. Commentators call it presumed income because it might have absolutely no bearing on your actual current financial situation.
Why would they do that? Why a historical look back instead of just asking what you make today?
The legislative intent was to prevent strategic manipulation. Lawmakers were afraid that if the test only looked at your current income, you might say, quit your high-paying job for a month, file Chapter 7, and then go right back to work debt-free.
So they wanted a snapshot that was harder to gain.
Right. But it creates these immense hardships. Imagine a software engineer who earned big bonuses for 5 of the last 6 months but was abruptly laid off last week.
Their income is now zero.
Their income is zero. But the means test would likely show a presumption of abuse because it's averaging in 5 months of high bonus income. The law sees their presumed income as high, and it effectively forces them into a hypothetical Chapter 13 plan based on a salary they don't even have anymore.
That rigidity is the whole point then. It's the mechanism to push people into reorganization.
That's exactly what it is.
So are there any legitimate ways around this? What about business owners?
There is an escape clause. The means test is inapplicable if your debt is not primarily consumer debt.
The business debt exception.
Exactly. If more than half of your debts are from a failed business inventory loans, commercial leases, that sort of thing, you can proceed with Chapter 7. The law recognized that business failure involves different risks that shouldn't be judged by this consumer-focused formula.
But for that laid-off engineer, their only hope is to invoke the special circumstances clause. Is that just an appeal to the judge's mercy?
It's not mercy. It's a detailed mathematical override. The special circumstances clause lets you adjust your income or expenses for documented situations, like a serious medical condition or being called to active military duty.
And the requirement here is super strict, right?
It's severe. The assumption of abuse is only rebutted if those adjustments, the lost income or the new expenses, are significant enough to change the numerical outcome of the means test.
So you can't just say you have a costly illness.
No, you have to prove that the illness-related costs mathematically lower your disposable income below that statutory threshold. It requires documented evidence that fundamentally alters the formula.
Beyond all this math, BAPCPA also imposed two mandatory educational hurdles. This wasn't just about screening people out. It was about mandating behavioral change.
It was a huge philosophical shift. First, for eligibility. You are ineligible to file unless you get an individual or group briefing from an approved nonprofit credit counseling agency within the 180 days before you file.
So you have to seek advice before you even go to court.
Right. The idea is to make sure you've at least explored alternatives to bankruptcy.
And the second hurdle comes after you file, and it's tied directly to the discharge.
Correct. After filing, all individual debtors have to complete an instructional course concerning personal financial management. And failure to complete this post-filing course is explicit grounds for denial of your discharge.
So the court is saying, we'll wipe out your debt, but only if you prove you're committed to financial literacy moving forward.
That's the mandate. It completely transforms Chapter 7 from a simple legal proceeding into a regulated rehabilitation process.
So BAPCPA wasn't satisfied just regulating income. It went after assets, too. The legislature was really concerned about debtors moving states, forum shopping, to get better exemption laws.
This is a direct response to a few high-profile cases where wealthy people moved to, say, Florida or Texas, which had these unlimited homestead exemptions right before filing bankruptcy to shield millions.
So BAPCPA closed that loophole.
With extremely strict look-back rules for your domicile.
Okay, run that rule by me again. It sounds like a bureaucratic nightmare.
It is a detailed calculation based on a 2.5-year look-back. If you moved states within 2 years of filing, you can't use your new state's exemptions.
You have to use your old state's exemption.
You have to revert to the exemption laws of the state where you were domiciled for the majority of the 180-day period preceding those 2 years.
Wow. So you could be living in state C for 18 months, but be legally bound by the exemption laws of state A where you lived 30 months ago.
Exactly. It's incredibly complicated.
What happens if that rule just screws you over? If the old state's laws don't offer any exemptions for your assets?
The law anticipated that. If the rule would render you ineligible for any exemption, basically leaving you with nothing, there's a fail-safe. You can then choose the federal exemptions. It ensures you're not completely stripped bare, but it certainly complicates things.
The other major restriction BAPCPA imposed was specifically on the homestead cap.
This was a direct assault on using the homestead exemption to shelter other assets. BAPCPA capped the amount of equity you could add to a homestead within 12,215 days. That's about 3 years and 4 months before your case.
What's the specific limit on that?
The provision limits any value in excess of $125,000 that was added to the homestead during that period. The goal was to stop people from selling off stocks and sinking that cash into home improvements or a new, expensive house right before filing. That conversion is no longer protected beyond the cap.
Are there exceptions?
A few. The cap doesn't apply if the value was just transferred from another homestead in the same state. And it also doesn't apply if the debtor is a principal residence family farmer.
Okay, beyond the house, BAPCPA also made it harder to protect personal property from creditors by severely limiting lien avoidance.
This was a massive win for lenders, especially those who finance furniture and electronics. Lien avoidance lets a debtor eliminate certain liens on necessity items to help with the fresh start. BAPCPA drastically narrowed the definition of household goods for this.
How specific did they get?
Painfully specific. For electronic equipment, it was limited to 1 radio, 1 television, and 1 personal computer with its related equipment.
Wow, so they really got down to 1 TV, 1 radio.
Yes, it was a legislative judgment on what's a necessity versus a luxury.
And what key items got explicitly kicked out of the definition of protected household goods?
Several common assets. Works of art not created by you or a relative. Jewelry worth more than $500, unless it's a wedding ring. And critically, motor vehicles were explicitly excluded. It became much harder to strip a lien off your car and keep it.
These changes all point to the same theme: maximize creditor recovery and tighten the rules for the debtor. What other big changes did BAPCPA bring?
We saw several timeline restrictions. First, the time between multiple Chapter 7 discharges was extended from 6 years all the way to 8 years.
Discouraging repeat filings.
Clearly. And the number of debts you could discharge was also reduced. They tightened the rules for debts on luxury goods you bought right before filing. And as we said, they made the undue hardship standard for student loans even harder to meet.
Let's talk about the automatic stay. That's the core shield that protects the debtor the second they file. It stops foreclosures, collections, all of it. BAPCPA limited that too.
It put sharp limits on it, especially for repeat filers. If you had a previous bankruptcy case dismissed within the last year, the new stay is automatically limited to only 30 days.
So the default is now non-protection, if you filed recently.
Right. You have to petition the court to extend it and prove the new filing is in good faith. It's not automatic anymore.
And it also carved out specific exceptions for housing, which is critical for struggling renters.
It did. If your landlord already has a judgment of possession before you file bankruptcy, the stay is severely limited. You have to immediately deposit rent with the court. If you don't pay the landlord in full within 30 days, the stay is lifted and the eviction can proceed.
So bankruptcy is no longer a guaranteed eviction shield.
Not at all. And the stay is completely inapplicable if the eviction is based on immediate safety concerns like endangering the property or the illegal use of controlled substances. The court views those as emergencies that supersede debt relief.
And finally, BAPCPA even gave a shield to the creditors themselves, limiting their liability if they accidentally violate the stay.
This was a major concession to the lending industry. Creditors are protected from penalties if the debtor failed to give effective notice of the filing.
And effective notice is defined in minute detail.
It is. The debtor has to send notice to a specific address the creditor filed with the court or to an address from 2 recent communications from that creditor.
So the burden is on the distressed debtor to do perfect administrative work, finding the exact right address for every creditor, or else the creditor can keep collecting without penalty.
Precisely. It shifts the risk of procedural error entirely onto the debtor, further complicating that fresh start. It just shows how much the law was engineered to protect the administrative processes of large lenders.
So we've seen that Chapter 7 is a mechanism of profound financial consequence. For a business, it's a necessary orderly death. For an individual, it's a hard-won clean slate, a discharge, but only achieved through the liquidation of non-exempt property and running the gauntlet of all these post-2005 restrictions.
The modern Chapter 7 is really defined by that tension BAPCPA introduced. The means test is this objective barrier, forcing those with mathematical capacity to repay into Chapter 13. And it imposes all these complex rules on property, residency, and financial instruction.
The law really did move debt relief away from a judge's discretion and toward these objective, unforgiving formulas.
Formulas designed to maximize creditor returns.
The ultimate goal, as we've explored, is to preserve Chapter 7 for the truly destitute. Yet, getting that relief is now so conditional, it requires administrative perfection in completing these mandatory courses.
And that leads us back to the final provocative thought about this balancing act. We've established that the law requires this specific, perfect notice for creditors to be held accountable.
Right, the burden is on the debtor to inform them correctly.
But on the debtor's side, their ability to get that hard-won discharge is now legally tied to completing a financial management course, a program that was considered experimental, whose effectiveness was only studied for 18 months.
So if the administrative burden of notice is so high for creditor protection, what does it say about the system that the debtor's mandated rehabilitation relies on a financial education program of uncertain, untested long-term effectiveness?
Exactly. How much of the burden of truly utilizing the fresh start now falls on the individual's ability to learn from these programs versus the legal system's commitment to ensuring that education is even meaningful? It's a crucial question for the future of debt relief.